Meeting number 46 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 1082 and the motion adopted on January 30th, 2023, the committee is beginning its study on extradition law reform. Today's meeting is taking place in hybrid format pursuant to order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few comments for the benefit of the witnesses and members. I won't go into the Zoom function because I think it's just members on. I'll just give you my time card slots. When you're about 30 seconds away, I'll raise this, and when you're out of time, I'll raise the red card. So hoping you'll just adhere to that so I don't have to cut you off, and I do the same with all members. Just simple reminder, anyone who hasn't selected their translation, please select the appropriate translation on your mobile device or in the office, in the committee room. So to begin our study, for the first hour of meeting, we welcome officials from the Department of Justice. Ms. Janet Henchy, Director General and Senior General Counsel, International Assistance Group, National Litigation Sector. Welcome. And Aaron McKee, Director and General Counsel, Criminal Law Policy Section. So welcome, and I think you have 10 minutes to make your opening remarks.
Monsieur le Président.
Oui.
Oui, je m'excuse, j'avais levé la main, si vous permettez. Je voudrais m'assurer, est-ce que les tests ont tous été...
The interpreter notes that the sound does not allow for proper interpretation. Interpretation will resume for in-person participants.
We're able to interpret you right now, so I was able to get your interpretation. I'm hoping that you can get interpretation for everyone else, from everyone else.
Oui, je reçois l'interprétation, ça va. Alors, je comprends que les tests ont...
The interpreter notes that interpretation will resume for in-person participants.
Okay. Everyone here in person can get interpretation? Yep. Yes. Confirming, Monsieur Fortin, that everyone here is getting interpretation.
J'apprécie. Merci, Monsieur le Président.
Thank you. Floor is yours.
Thank you. Good afternoon. My name is Janet Henchy. As was mentioned, I'm the Director General of the International Assistance Group at the Department of Justice, known as the IAG. The IAG is responsible for managing all requests for extradition to and from Canada on behalf of the Minister of Justice. I'm joined this afternoon by my colleague, Aaron McKee, who is the Director and General Counsel within the Criminal Law Policy Section of the Department of Justice. We'd like to thank you for inviting us to speak to you this afternoon about Canada's current law of extradition. Extradition is the process by which an accused or convicted person located in one country is surrendered to another country pursuant to a request by an extradition partner to face trial or the imposition or enforcement of a sentence. Extradition is an important tool of international cooperation used by Canadian and foreign police and prosecutors to fight serious crime domestically and at a global level. Extradition proceedings are subject to different rules than criminal trials and do not mirror trial processes, as it's recognized that the trial will take place in the jurisdiction that is seeking extradition. A new Extradition Act was introduced in Canada on May 5, 1998, and received royal assent on June 17, 1999. It constituted a significant overhaul of the law governing extradition in Canada. Then Minister of Justice Anne McClellan, speaking to the Standing Committee on Justice and Human Rights, characterized the reforms brought forward by former Bill C-40 as important and long overdue, and responding to criticisms that Canada was not an effective partner in the fight against international criminality due to our then antiquated extradition laws. She described the proposed laws creating a uniform extradition procedure that would apply to all requests for extradition and provide procedural and human rights safeguards for the person sought, noting in particular that it would set out clearly, for the very first time, a minister's responsibilities and duties to ensure the human rights and fair treatment of the fugitive will be safeguarded in the other state upon the fugitive's return for trial or to undergo sentence.
The Extradition Act of 1999 is the piece of legislation that currently legislates extradition in Canada. The Minister of Justice is responsible for managing Canada's extradition agreements and of enforcing the Extradition Act. Within the Department of Justice, the Council for International Assistance Group have delegated authority to exercise most of the functions of the minister under the Act. The Supreme Court of Canada confirmed the constitutionality of the Extradition Act since it was enacted, as well as the constitutionality of handing over persons for whom a request is made for extradition under the Act for a number of circumstances.
Code that governs an extradition request from its receipt until its conclusion. We have provided you with an infographic that outlines the various stages of the extradition process within Canada. I hope that you have it. I will take a few minutes to describe that process for you. Pursuant to the Extradition Act, Canada may only extradite to an extradition partner, which is defined as a state or entity with which Canada has a bilateral extradition treaty or is a party to an applicable multilateral treaty, or whose name is listed in a schedule to the Extradition Act. Canada has 51 bilateral extradition treaty partners, and there are 34 designated partners identified in the Extradition Act. Canada is also party to several multilateral conventions containing provisions on extradition. At the outset, it's important to be aware that extradition agreements are reciprocal in nature and provide a mechanism for Canada to make requests for extradition to its partners and, in turn, to execute requests on their behalf. Reciprocity is a key feature of extradition, as is the principle of international comity, meaning the mutual respect that partners have for the differences that may exist between our respective laws and judicial systems. When a state makes an extradition request, it is the law of the country receiving the request that governs. Le processus d'extradition au Canada.
Canada's extradition process composes three components. First, the authority to proceed, the decision of the IAG to allow an extradition procedure before the Canadian courts. Second of all, there's the judicial phase. The extradition hearing is when it takes place. And third, the ministerial phase. The Minister of Justice makes the decision if the person sought should or should not be surrendered.
When a formal extradition request is received, it is reviewed by the IAG to determine if it meets the requirements of the Extradition Act and the applicable treaty. In assessing whether an authority to proceed should issue, the IAG will check that the request concerns extraditable conduct within the meaning of Section 3 of the Act, which means the party seeking extradition is an extradition partner, as defined in the Act. The person is being sought by the extradition partner for prosecution or for the imposition or enforcement of a criminal sentence. Subject to a relevant extradition agreement, the foreign offense in respect of which the extradition is requested is punishable under the law of the extradition partner by imprisonment of a maximum term of 2 years or more. And finally, and perhaps most importantly, the alleged criminal conduct of the person, had it occurred in Canada, would have constituted a criminal offense in Canada, which is known as the principle of double criminality. The authority to proceed, if issued, authorizes the commencement of extradition proceedings before a superior court judge in the province in which the person sought for extradition is located. At the hearing, the requested state is represented by counsel for the Attorney General of Canada in the region where the person is located. The person sought is entitled to be represented by counsel of their choice, and if they cannot afford counsel, they may apply for legal aid. À l'audition d'extradition.
At the extradition hearing, the extradition judge decides whether the person who is sought would be incarcerated because of their extradition based on the evidence provided by the state making the request. At the hearing, the extradition judge decides whether the evidence submitted on behalf of the other state to the Attorney General of Canada would justify trial if this had been occurred here. And again, this is the double criminality test. If the judge is convinced that the evidence meets these criteria, they order the incarceration of the person while waiting for the Minister of Justice's decision. Otherwise, the extradition judge orders that the person be freed.
Middle phase, counsel for the person sought may bring various motions, raise objections, seek additional time to prepare, etc. If the judge orders the person committed for extradition, the case returns to the Minister of Justice, who must personally determine whether to order the person surrendered to the requesting state. Counsel for the person sought for extradition may choose to make written confidential submissions to the minister to assist them in making a decision on surrender. The minister's decision must balance the interests of the person sought for extradition against Canada's international treaty obligations. The Extradition Act sets out a series of mandatory and discretionary grounds for refusal to surrender. Mandatory grounds of refusal are if the surrender would be unjust or oppressive, if the request was made with the intention of prosecuting or punishing the person sought on the basis of enumerated grounds of discrimination, such as race, religion, or ethnic origin, if the prosecution is barred by prescription or exceeds the limitation period, or if the conduct is considered to be a political offense. Discretionary grounds may include if the person was less than 18 years old at the time of the offense, if the conduct did not occur on the territory of the extradition partner, or if the person has already been convicted of the offense in Canada, which is the principle of double jeopardy. The minister must also be satisfied that surrender would not be contrary to the Charter.
The person sought may appeal the judge's incarceration decision, and if extradition is ordered, may ask for a judicial review of the minister's extradition order. If the appeal court confirms the judge's decision and the minister's decision, the person sought may ask authorization to appeal one or both decisions to the Supreme Court of Canada.
Each individual case is assessed on its own merits in accordance with Canadian law and the Canadian Charter of Rights and Freedoms. So with that introduction, I didn't go over my time, we would be happy to answer any questions you may have about the process.
Thank you. That was actually 30 seconds under time, so that was excellent. Didn't have to interrupt you. I'll go to the first round of questioning to Mr. Moore for 6 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for appearing here today on this study. Can you comment, the decision of the Supreme Court in the Burns-Raffay decision ruling that Canada had to seek assurances from a foreign jurisdiction that an individual in Canada would not receive the death penalty should they be convicted of the offense which they committed in a foreign jurisdiction. Since that time, a lot of time's passed since that decision, and it impacted that decision, of course. How often has that ruling come into play with requests for extradition from Canada since that time?
I can't give you an exact number, but
does it happen, I guess?
It happens fairly frequently. As you can imagine, our biggest extradition partner is the United States because they're our only neighbor, and they have the death penalty in the United States. So whenever they make a request where the death penalty would be a possible sentence, we require a death penalty assurance, and we receive one. It's very commonly provided. We also get requests from other countries with the death penalty, and we've never experienced any resistance to providing us with an assurance. And as you can imagine, of all the assurances that you get, it's the easiest to monitor. We've never had the situation where it wasn't respected.
Okay, and what other assurances go into that decision-making process? When you're looking at that extradition request, what are some of the high-line things that you're looking for? And does that vary? We have a number of extradition agreements with, I think you'd said over 30 countries?
We have 51 extradition treaties, and then we have designated partners that are listed in the Act.
So what other assurances would typically be requested?
So we only seek assurances where extradition would be otherwise unsafe. So the minister needs to make a determination about whether he should be ordering extradition at all. And so sometimes he would determine that it's not appropriate to extradite in a particular circumstance. But sometimes it's possible to overcome the problems that you might face in the requesting state through assurances. It doesn't happen very often other than the death penalty assurance. So the death penalty assurance is our most frequently sought assurance. Then very infrequently we'll be in a situation where we might need to seek an assurance with respect to access to consular services for a Canadian citizen who is being extradited somewhere that we aren't as familiar with. Sometimes we ask for assurances with respect to a person being held in a particular prison where a country has issues with some prisons, but we have information that one prison is safer than another. Sometimes we have assurances that our consular officials will be allowed to monitor a trial that's taking place in another country. But it's pretty unusual to ask for assurances. There's only a handful of cases I can think of other than death penalty cases where we've sought assurances.
And have you, since that decision was made, have you ever seen a instance where there is, in this day and age of mobility that we have, is there ever seen an instance where there's a race to the border scenario where someone being aware of the assurances that we demand as a country before extradition is allowed is making an effort to get back into Canada for that purpose?
To avoid their trial in a particular country in order to get assurances from us. I'm sure it's happened. I can't tell you that I have any particular cases in mind, but our border with the United States is so easily crossed that I'm sure there's been circumstances where someone has come back to hopefully avoid prosecution, and in the end they got the benefit of assurances.
Okay. And so when you're looking at the extradition treaties that we have in place now, how often would they be reassessed? And what would trigger a reassessment of those treaties, or are they reassessed very often?
Well, as a starting point, although I've listed a large number of treaties, many of them have not been used in a long time.
Okay.
So we have sort of frequent treaty partners such as the United States, the UK, Australia, France, and some of the Western European countries. Those are the most frequent countries for seeking extradition from Canada, and for us to seek extradition from them. So we have some treaties that we haven't used in a long time, and those would be treaties we'd potentially want to reconsider. But until recently, we haven't had the mandate to renegotiate or renew old treaties, and it's only in the last 3 or 4 years that we have been provided with funding and the mandate to look at our treaty network and renegotiate where we think it's appropriate, and look to negotiating new treaties where we are missing treaties.
Okay. All right. Thank you.
Thank you, Mr. Moore. I'll next go over to Ms. Briard for 6 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chair, and thank you to our witnesses for being here today. Thank you also for the flowchart you've shown us. I would go in the same direction as my colleague, Mr. Moore. Given the changes that are happening around the world in terms of cybercrime, war, and so on, do you believe this review of these treaties would be necessary to make sure everything is up to speed to today's world?
Question, which is, do I think that it's necessary to revise some of our treaties? Yes. Some of them could use amendments because the law has changed over time as well. So there's things that are missing from some of our older treaties that we can't do because they're not provided for. For example, in the many years ago, it was the practice to list the offenses that were covered by an extradition treaty, and as time passes, new offenses come into play that didn't exist, say, 30 years ago. And those treaties that have the listed offenses, we cannot extradite for anything that isn't listed in the treaty. So more modern treaties will have a provision that allows for any offense of a certain severity to be falling under the treaty. So that is a much more flexible approach to the negotiation of a treaty. And so yeah, we do think it's worthwhile to look to those old treaties and update them.
Merci. Thank you.
Thank you. Could you tell us more? You talked about double criminality. Could you give us more detail on that, please?
criminality is really kind of a fundamental base of extradition. The principle is that we will not extradite to, and other countries will not extradite to us unless we're satisfied that whatever the person is charged with in that country would also be a crime in our country. So that is assessed in Canada under something called a conduct test, which means that we look to the evidence that's been provided to us about the crime, and we ask the question, if we had that same evidence of conduct in Canada, would there be a criminal offense that would arise from that conduct? The approach is flexible because it takes into account the fact that the way that offense is characterized in one country might be different. So if you just say, the offense is called this, we might not call it the same thing, but it might still be a criminal offense here. So by looking at the conduct rather than the name of the offense, we have a lot more flexibility.
Vous avez aussi parlé de...
You also talked about the evidence, and we know that, as you mentioned, the extradition process goes through a very specific legal process, not the usual criminal process that we're familiar with here in Canada. Evidence is the same thing? Does the consideration of evidence follow the same rules as the rules we're familiar with here? It's a case, it's a whole file of evidence that's presented?
A little bit different from what you see in a criminal trial, and what's used for evidence is something called a record of the case, and the record of the case summarizes the evidence in the foreign country. It will indicate that this witness will say this and that witness will say the other thing. So instead of putting forward actual witnesses because they're far away and maybe don't speak the language of the proceeding in Canada, their evidence is summarized, and then the record of the case is certified by usually the prosecutor who's putting it together to say that he is satisfied of its accuracy and that evidence is available for trial at the time if the person is surrendered. So the rationale behind it is that it's too complicated to bring in witnesses from other countries, and at one point, prior to the current legislation, we had affidavit evidence that was provided, but what we discovered is a lot of countries don't even understand the concept of an affidavit, which is a sworn statement from a witness, and so this approach has proven to be more effective in allowing other countries to understand how to provide us with evidence.
Maintenant qu'on sait...
Now that we know that there are things that can be done online, perhaps having other witnesses appear from other countries over Zoom could be something to think about.
I can't really respond to that. There's also, of course, there's time changes and language differences. So I think it would be complicated, but that's not for me to consider.
Now, with that double criminality and the evidence, do you believe the rights of these individuals are recognized and protected properly?
As I mentioned in my introduction, there are a lot of provisions in the legislation to address the rights of the individual, and the whole concept behind the Extradition Act is the importance of balancing the rights of the individual against the interests of the requesting state to have them brought there for prosecution. So yes, there are a lot of provisions that allow for the rights of the person to be protected. They can make arguments before the extradition judge. They can make arguments before the Minister of Justice. There are no restrictions, for example, to what can be said to the Minister of Justice. So they can bring forward concerns about their health, concerns about the treatment they will get in the foreign state, concerns about treatment in prison, concerns about the length of their sentence. There's pretty much nothing that they can't raise before the minister, and the minister will consider it and issue written reasons for his assessment of what they have said, and that then goes before the court if they choose to bring a judicial review. So everything that happens either before a judge, before the minister, and then can be appealed before the court or judicially reviewed, and then there's the opportunity to go before the Supreme Court to seek leave if unsatisfied with the outcome of the appeal. So there's a lot of opportunities to recognize the rights of the individual.
Thank you. Thank you, Ms. Henchy. Thank you, Ms. Briard.
Thank you.
Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
The interpreter notes that Virtual sound does not allow for interpretation. Interpretation will resume for in-person participants.
Importante, c'est de déterminer si le crime dont on veut accuser l'individu est également reconnu au Canada comme étant un crime. Et je comprends qu'il peut y avoir une audition pour le déterminer.
Sorry, Mr. Fortin, there's no translation. I'm just going to check if there's a problem with them hearing yours or there's a channel issue. Just pause for a minute. I'll reset your time.
Okay.
You want to say something and we'll just see if translation is okay
Oui.
or if the translators
Alors,
can tell the clerk? Any
Oui,
issue?
alors j'espère que ma traduction va fonctionner, qu'on me reçoit.
The interpreter notes that online sound does not allow for proper interpretation. Interpretation and safe interpretation will resume for in-person participants.
Vous devriez être en mesure de m'entendre correctement. Je sais que tantôt,
Monsieur
j'ai
Fortin,
passé mon micro.
They're
Oui.
saying they're not able to interpret for online participation as the sound quality is not there. So I don't know how we're going to wrestle with this. I will maybe go to your round in a subsequent round. I'll go to Mr. Garrison if you're okay while they figure it out.
Non. Monsieur le Président, je m'excuse, mais vous le savez, c'est important pour nous qu'en principe, le
Interpretation will be provided for in-person participants as online sound is a risk to the health and safety of interpreters.
Monsieur le Président, je vais vous demander d'ajourner si on n'est pas en mesure d'interpréter correctement maintenant.
Can you move your mic a little bit up?
Oh oui, je peux le bouger comme vous voulez, comme ça?
Is that helpful to the interpreters? Nod? No.
Non? Alors, je ne sais pas d'où vient le problème. Si je peux faire quelque chose d'ici, je le ferai avec...
The interpreter notes that it is the safety of online participation and not the member himself who is using the correct equipment. Interpretation will resume for in-person participants.
Mr. Fortin, the problem they're having apparently and is with the sound quality from your end. I know you've done everything right, and that limits their ability to translate. So I'm just going to ask while they figure it out if I can go to Mr. Garrison, then I'll come back to you. Hopefully we can resolve this in the next 6 minutes, if you're okay with that.
Mon problème, Monsieur le Président, c'est que je ne serais pas d'accord que l'audience se tienne alors qu'on a des problèmes de traduction.
The interpreter notes that interpretation will resume for in-person participants.
Francophone, il y en a d'autres. Il y en a autour de la table et il y a des gens qui nous écoutent présentement et qui sont francophones. Alors, s'il y a un problème de traduction, ça ne me lèse pas seulement moi, ça lèse également l'ensemble des francophones. Et si je devais ne pas être en mesure d'intervenir auprès du témoin au cours de la séance, ben, il y a un problème de démocratie. Alors, en tout respect, encore une fois, Monsieur le Président, je vais vous demander de suspendre l'audience jusqu'à ce qu'on ait réglé la problématique de traduction.
Bonjour, M. Fortin. Jean-François.
Hello, Mr. Fortin. This is Jean-François, the clerk of the committee. We're going to try to solve the problem. Mr. Sarai is asking if we could continue in the meantime and come back to you for your round of questioning.
Je viens d'expliquer, là, je ne sais pas si vous m'entendez.
Interpretation will resume for in-person participants.
Qui participent à ces séances-là. Et si on n'est pas en mesure d'avoir une traduction adéquate, ça pose un problème de démocratie. Et pour les traducteurs, ça pose également un problème auditif. Je ne voudrais pas que quelqu'un, je ne sais pas quel problème, on sait qu'on a déjà hospitalisé une traductrice là, parce qu'il y avait eu un choc, je ne me souviens plus comment on l'appelait, là, mais à tout événement, en tout respect, là, encore une fois, je demande qu'on suspende l'audience jusqu'à ce qu'on ait réglé les problèmes de traduction.
J'ai une question. Est-ce que si je parle...
If I speak French here, will the interpreters interpret for me? Yes? Okay. So, Mr. Fortin, the problem is not here in the room. The problem is something with your headset. That's what they're thinking here. The interpreter notes that the online online participants' sound is very difficult for interpretation. Interpretation will resume for in-person participants.
En Zoom et j'ai jamais eu de problème avec ce matériel-là. Donc, je ne sais pas. Si c'est mon appareil qui ne fonctionne pas correctement, il faudrait qu'on m'en envoie un nouveau. Sinon, je ne sais pas. Écoutez, je ne suis pas technicien en informatique et je n'avancerai pas de diagnostic, là, mais je peux vous dire que moi, je fais ce que je dois faire, ce qu'on m'a demandé de faire, de la même façon que chacun de nous le fait lorsqu'on est à distance.
Monsieur Fortin, I'm just going to suspend for a few minutes while they resolve this. So.
Merci, Monsieur le Président.
So we resume the meeting only to advise you that we will be adjourning as we have not been able to resolve this sound issue, interpretation issue. So we will have to reschedule the subsequent witnesses, and perhaps we will have to reschedule the current witnesses as well, maybe for a shorter period of time, half an hour to get a round of questions that were remaining from them. We'll figure that out. So sorry about that. It's the first for me, and I apparently from the clerk, it's the first for him as well. So hopefully we'll get this situation resolved for the next time. Thank you, and thank you to the witnesses. And if the other witnesses are listening, I sincerely apologize to you who've had to wait on Zoom or online for this. So you're also dismissed. Thank you. Rob, you know it's all